interpretation. This is week 2, and this week we're dealing with the issue of creating legislation. Now, in Introduction to Law and through your study guide and your text, you'll see the way in which legislation is presented as a bill into Parliament. There are reading speeches, there's a matter of the bill being passed, and then royal assent. And that royal assent signifies the commencement of the Act. The Act can have deferred effect, or it can have immediate effect. And of course, even within a piece of legislation, there may be a combination of those things. So in this session, I'm not dealing so much with the mechanics, if I can use that term, of how legislation is created, but I'm looking at the creation of legislation in a broader sense. As you might expect, from what we've already discussed, the way in which you consider the use of an interpretation of words is highly significant in our study of law. What that means is that we need to become experts in the language of law and the use of language generally. In this unit, we consider, amongst other things, how to read legislation, and one of the best ways of doing that is to see how legislation is written. So I'll take you to a couple of sources now that, or during this session, that aren't part of the prescribed material, but do provide you with some background and some knowledge. So that will assist you in terms of reading the material. This is, if you like, a practical subject in the sense that ultimately we want you to both interpret legislation, read it, but then write about it correctly. And we want you to graduate with an ability to convince those around you that you can write and do so in a manner that is consistent with standard legal practice. Now, last week, we finished off with a discussion generally about the Acts Interpretation Act of Queensland. Let's look at that in more detail now. And as I speak, I'll be sharing the screen. Hopefully now you see the Acts Interpretation Act as at 4 December 2020. If not, please draw from your sources to have that act up on your screen. So the Acts Interpretation Act in Queensland was created in 1954. And you'll see from the material on screen that the version I have on screen now is as it was on 4 December 2020. As we discussed last week, you will need to find a way of determining what the versions of the Act were, not just this Act, but all Acts, at various stages. And whilst I'm in Oxley at the moment, I think Queensland legislation provides a better way of doing that in my experience. So do have a look at legislation from a number of sources and be familiar with their advantages and disadvantages. The Acts Interpretation Act provides for the long title. And I'm just going to go through basically the first half of the Act, or at least through to about section 20, and then we'll come back to it in later tasks. Not every section, but just some of the ones that I think are very critical. Now, why do we go to the long title? Well, it is an important part of intrinsic material to look at the title because it gives a clear idea of the purpose of the legislation. It also provides for some context in relation to the legislation. So in this case, what is the Act's interpretation about? Well, it's an act to assist in the shortening and interpretation of Queensland Acts. What do we mean by shortening? Well, rather than having to describe something, sort of generic application in legislation, when you read the specific legislation, it will be provided for in some degree in shorthand. And you as a lawyer, being able to successfully interpret the legislation, need to be alive to the fact that the Parliament, in creating that legislation, may have used legal shorthand, which means that you need to refer back to the Acts Interpretation Act to get the longer, more extensive version of that which is meant. Now, that may not be apparent just yet, but you'll need to identify what's in this Acts Interpretation Act with a great deal of detail so that you will be alive to when it comes into play in other interpretation. And the other thing is it's designed to assist in the interpretation of Queensland Acts. So it has that dual purpose. The Act applies to all acts. We can see that in subsection 2. It also binds the Crown, and it can be displaced by contrary intention. So whilst I mentioned that this Act is intended to have general application when reading and interpreting other pieces of legislation in Queensland, the general material contained in the Acts Interpretation Act is subject to being overridden by specific, clearly stated intention appearing in other pieces of legislation. And that leads us to another general principle of interpretation, and that is that where there is an apparent conflict between the general and the specific, it is the specific that is designed to overrule. So in this instance, if there's a contrary intention in another piece of legislation, go with it rather than the Acts Interpretation Act. The Act binds the Crown. Now you'll see a reference to the Crown often in the study of law. What does it mean? Well, it's actually fairly difficult for me to describe it accurately, but I can provide you with an analogy that I think works pretty well. It's not exact, but you get the idea. And the Crown is, if you like, to Queensland, in a global sense, what the term the household is to a particular house and the occupants of that house. So if we think about a house, it may have mum and dad, and it may have 2 kids. It may have a grandparent, for example. It might have a dog. So they're the occupants of the house, if I can say that in general terms, and they then represent through themselves and their collective activities the household. So in terms of the state of Queensland, think of the Crown as representing the household, the occupants and the general activities of the occupants within the state. It's my best analogy. If you can come up with a different one or better one, then please leave a comment or ask through Q&A. The Act means an Act of Queensland Parliament and refers to a British or New South Wales Act in force in Queensland, etc. Now, we don't get too many of these, but it's still potentially relevant. And that section is really a throwback to the history of the creation of legislation in Queensland. As always, when reading legislation, look at the overall headings. Again, you'll note there's no chapters here. We go straight into parts. Part 2 talks about the meaning of the Act. Part 3, general provisions applying to acts of a general nature. So not just this one. I'm going to ask you to read all of those in detail, but now point to some that have particular application. Section 14 provides that for what is in and what is not part of an act. I mentioned last week that when you read an act, look at the headings. They give you a hint. Well, Section 14 says that the headings are not there just to provide some overall structure. Indeed, they are actually part of the Act. So you can refer to the headings with as much force and effect as the content of the section itself. In fact, if you look through those subsections of section 14, you'll see that everything is included as part of the Act, even punctuation, even schedules and appendices, even examples. There's one exception. Number 7, a footnote or an editor's note to an Act or a provision of an Act or an end note to an Act, they're not part of the Act, but otherwise everything is part of the Act. Section 14A is critically important. Now, firstly, you'll note it's section 14A, it's not section 15. And you might be alive to why that is the case. It was introduced as a result of an amendment to the original legislation. So if you look at the Acts Interpretation Act 1954 as it was when passed, of course, there was no 14A. So what that tells you is that it's something that was introduced. Therefore, there must have been a reason for it to be introduced. And often the introduction of some amendment to an act comes about as a result of one of two things. Number one, it may be to reflect government policy of an incoming government elected on a promise of doing this or that, which is then reflected in the amendment to the legislation, so as to give, if you like, that election promise the force of law by introduction of the Act. The second reason why there might be a subsection introduced or a variation generally is as a result of a case. Now, I mentioned that Parliament, and through Acts, override the courts and case law, but it's a circular thing. You see, it works like this. Laws are introduced. Laws, as introduced, can't cover every scenario that occurs, which means that a dispute will arise, and that dispute may well find itself in court. The courts then make a decision. Is the plaintiff correct? Is the defendant correct? And if so, why? That reasoning of the higher courts becomes something that other courts rely upon when interpreting that provision or interpreting other provisions by analogy, for example. So the decision of the higher court becomes part of our law. It becomes part of our case law. It becomes part of our common law. It's subject to the general rule of precedent, stare decisis, and other courts, particularly lower courts, are then bound by that decision and therefore must apply it when applying a similar case. Now, courts make that decision, but the court's decision is not always popular with Parliament. And Parliament may then take some specific action to override the effect of that case by introducing new law in the form of statute, which means that courts then look to the law and not the case, and therefore not the common law on that point. So there's some of the reasons why the Acts may have been amended. Part of your task as proficient interpreters of statutes is to be alive to the issue of amendment, and you'll need to work out a way of determining a couple of things. The first is the when, and the second is the why. As for the when, you should be able to undertake research, and I'm not going to tell you, but you should do, and please do this as an exercise, work out when section 14A, for example, was introduced into the primary legislation. When was it effective? The second thing is, why did it come into existence? Now, how could you find that out? Well, one of the things you could do is look at news reports of the day. You could read textbooks, secondary sources of law that might give some ideas. But there is a very important resource that all good interpreters of statutes must become familiar with, and use, and that is the material produced by Parliament leading up to the introduction of a bill and the passing of that bill as an Act of Parliament. And that is primarily second reading speeches and explanatory notes or explanatory memoranda, depending on whether you're talking state or federal. The latter are very important extrinsic materials that go to assisting directly on the appropriate interpretation of the Act. So if you read the amending Act that introduced, so for example, Section 14A, and you look at Hansard, and just on that, I've got a YouTube clip on how to access Hansard. If you look at Hansard and you look at the second reading speech, you'll get an idea of what this is all about. It'll help you if you're formulating arguments or trying to come to a conclusion about how a piece of legislation should properly be interpreted. And the other thing is the explanatory note, for example, in Queensland, which provides detail about each of the sections of an Act, whether it's an originating Act or an amendment Act, that provides detail as to what it is and why it's there and when it was, and why it's needed. So all of those things are very important because they go to demonstrate the purpose of the Act. They go to provide some context as to why the legislation was introduced. And if you look now at the heading of Section 14A, you'll see that it very importantly talks about the interpretation and purpose. You see, the word purpose is a term of art in statutory interpretation. It's one that you should use on a regular basis. It's a go-to word. But what is the purpose of the legislation? Because that's a key element to interpreting it correctly. Section 14A says that when you're interpreting a provision of any Act, the interpretation that best achieves the purpose of the Act is that which is preferred. That won't help you unless you know what the purpose of the Act is. So you've got to broaden your reading so that you can say with some certainty and have authority for a proposition as to what was the purpose of the Act. That means is that in some way you need to channel yourself into the mind of Parliament, so to speak, to determine the purpose. Subsection 1 does not create or extend criminal liability. And number 3 is it's declared that this section applies to an Act passed after 30 June 1991. That might give a hint as to when it was introduced, despite any presumption or rule of interpretation. Now, have a look at the example. Now, when I look at that example, I'd ask myself, is that part of the Act, or is it? Can I rely upon that in a legal argument, or is it just there to help me through? We'll go back to the previous section. What's part of the Act? Subsection 4. A note in an Act, as opposed to a footnote or editor's note or endnote, is part of an Act. Example, see the note to Section 2. Example of a footnote, see the footnote to Schedule 1. So it is part of the Act. So when you look at an example, read it carefully. It's designed to assist you, and it does assist you. So in this instance, it says there's judicial authority for a rule of interpretation that taxing legislation is to be interpreted strictly and in a taxpayer's favour. For example, in Partington and AG. Despite any such possible rule, the section requires a provision imposing tax to be interpreted in the way that best achieves the Act's purpose, whether or not to do so would be in the taxpayer's favour. Now, that's a really interesting example because what it does is demonstrate an interplay between the common law and statutory law in a very effective way. So one of the rules of common law, judge-made law, long-standing principles is that where you have legislation interpreted in the taxpayer's favour, without saying that doesn't necessarily exist. They say it's a possible rule. This section is saying, as part of its purpose, that you must always consider imposing the legislations in a way that best achieves the purpose of the taxation legislation, not necessarily whether it's in favour of the taxpayer or not. Keep that in mind. All right, the next section is 14B. I've mentioned a couple of times now the way in which you use intrinsic material, that which is contained within, and extrinsic material, that which is contained without, in interpretation. Section 14B, a lot of these sections have counterparts in the Commonwealth Acts, Interpretation Acts as well, is right on point because it talks about how to use extrinsic material in interpretation. And the interpretation of an act does assist in interpretation generally. And it talks about considering the use of extrinsic material in ways of assisting interpretation. And this is really important. So use this and apply it. If the provision is ambiguous or obscure, then extrinsic materials provide an interpretation of it. So we looked at some sections last week that at first glance seemed a bit ambiguous or obscure. You need to look beyond. If you want to know how to interpret such legislation, then you can use extrinsic materials and you have the authority to do so. So if you're standing in a court where you're preparing an opinion or an answer and you say, I rely upon this extrinsic material, A, B, C, and you're challenged, what's your authority for relying on that? Then you say, well, section 14B specifically, section 14B 1A specifically authorises me to do so. All right, fair enough, please continue. 14.1b says, if the ordinary meaning of the provision leads to a result that is manifestly absurd or is unreasonable, then you can go to extrinsic materials to provide an interpretation that avoids such a result. That's interesting. You know, in week one, I talked about black letter law. I talked about the distinction between common law and equity, which we all now together is sort of all common law. If you interpret an act and it comes to a really manifestly absurd or unreasonable outcome, then you go to the extrinsic materials and that will guide you in terms of how to actually read and interpret that legislation. Now, those of you currently doing or have done Introduction to Law may have picked up that that looks very much like the Golden Rule, which is one of the common law methods of interpretation, the Golden Rule. Now, I'll just digress for a moment and say this. It's very common for lecturers in statutory interpretation to talk about the common law rules in week one. I'm going to mention them, but I'm then going to gloss over them. I'll come back to them in about week 9 or something and talk about the literal rule, the Golden Rule, and talk about how these rules provided the way in which statutory interpretation started. Now, the reason I don't do that is that's not the current law. It provides very valuable historical context, and you need to know it. But I'd rather teach you the law as it is, ingrain that first, and then we can introduce the common law principles. But I'll just say that 14.1b really does look very much like the Golden Rule. Now, 14.1c says, in any other case, this is interesting because the first one said, if the legislation is ambiguous or obscure. The second one says, if it leads to a manifestly absurd or unreasonable result, then you can look at extrinsic materials. 14.1c says, look, in any other case, you can still use extrinsic materials That is, if you wish to confirm the interpretation conveyed by the ordinary meaning of the provision is correct. So what I encourage you to do is always use extrinsic materials. In year 2, when you're providing a response to a constitutional question, don't forget about statutory interpretation. Use section 14B or administrative law or contract law or whatever it is in consumer law. Use 14B to give yourself license to introduce extrinsic materials. You do so, I can guarantee you'll get better marks. Remember, of course, I've taken many of these units at university, so I look for these things if I'm doing second and third year units. So always consider the use of extrinsic material. And subsection 2 says, in determining whether consideration should be given to it or not, and determining the weight to which you give it, lawyers talk about weight a lot. We talk about it in an evidentiary sense. We heard from this witness who provided evidence, but I don't give much weight to it because of this and that. So lawyers talk about the quality of something and the weight to which we give it. Having regard to the desirability of the provision as its ordinary meaning, undesirability of prolonging proceedings without compensating advantage and other relevant matters. Now, subsection 2 is a really good common sense matter. And what that says to me is always be mindful of statutory interpretation, always be mindful of the use of extrinsic materials, but from a practical sense, let's not go too far. If something is written in a plain language where the ordinary meaning of the provision is quite clear, then even though I'm saying always at least consider, have in the back of your mind extrinsic materials, don't use extrinsic materials in every instance. That would be an overkill. And I know I'm asking you to exercise some discretion and some judgment, but just keep in mind the use of extrinsic materials and its place in interpretation. And what do we mean by extrinsic material? Well, there we have a definition. It means relevant material that's not part of the Act. Well, what is part of the Act? Go back to section 14. Then you'll see exactly what's part of the Act. Everything else is extrinsic, including, for example, a report to a royal commission or similar body that was laid down before Parliament enacted the provision. Oh, now that's great. So now it's telling us another source of where we can find relevant and persuasive extrinsic materials. You want to know something more about what a section says and why it says it, why it was introduced, what's its purpose. You can have a look at the reports of the Royal Commission or committees of inquiry. Law reform commissions are valuable. I have taken advanced statutory interpretation. We go into this a lot in advanced statutory interpretation. I point you to specific resources. Time permitting, I'll try and do some of that as well. The next one, reports of committees of the Parliament. That's really valuable because those reports of committees provide a great deal of relevant detail, statistics, information, précis of the law leading up to the introduction of the Act. It's really good. Treaties or international agreements mentioned in the Act. Now, just on that point, Australia, of course, is signatory to many treaties, conventions. We are part of the international law of bodies, international bodies and states. But because when we sign up to a treaty or a convention or something of that nature, it doesn't become part of our law. It's a common misconception there. Parliament needs to enact something specific into our law for that, which was something we agreed to in a convention to become part of our law. But you can still look at the treaty to give an idea of what it's all about. Now, of the list, probably E and F are the most important. E, the explanatory note or memorandum, In the state parliament, we talk about mostly explanatory notes. Commonwealth, we normally talk about explanatory memorandum. Now, these things relate to a bill containing the provision given to the members of the parliament by the member bringing the bill before the parliament to explain what it's all about. And a speech, the second reading speech, is the one to look at by the member when introducing the bill. And then the official record of proceedings in Legislative Assembly, that's Hansard, is G, and any other documents. Okay, so that's a really good example of where you look to for the extrinsic materials. Extrinsic materials, in a broader sense, might be regarded as secondary sources of the law, such as textbooks. But really, when we talk about extrinsic materials, I would use that list as what we mean by extrinsic materials. It does have the use of the word, permissive use of the word including, meaning it's not a closed list. It can go beyond that, but generally that's what we think about when we're talking about extrinsic materials. And the ordinary meaning is defined there in that section as well. All right, so you can see that when you read legislation, it provides you with a whole range of questions that you might ask yourself. But if you look at the detail carefully enough, it also provides you with a lot of the answers beyond just quickly reading through the material. The next section that's relevant is section 14D. So I'll just skip ahead to D. Examples. And we talked about examples a little while ago. If an act does include examples, bear in mind that the example is not exhaustive and it doesn't limit, but it may extend the meaning of the provision. So don't make the mistake of treating the example as dominant. The example is in effect subservient to the provision itself. Now also have a look at section 14F, which refers to particular acts. Now this is the way in which an act may be cited. You'll see that word a lot, cite or cited or citation. And that is the way in which lawyers formally refer to something. So if an examiner asks you to cite your authority for a proposition, what that means is, tell me the legislation, tell me the case. If you can't find a source of primary law, find something from the secondary law to support your proposition. And when you're including material in a response to a question that you provide to the university, this is really important. You need to cite your reference. Now, the reason for that is you don't want to fall foul of laws to do with plagiarism. Really nasty if you do. So if you are basing some commentary on an external source, then acknowledge that, even if it's not a direct quote, by including a citation. If you're referring to a case, you cite the case by including the description of the case. So, for example, it might be 1934, CLR 107, which is the Commonwealth Law Reports from that year at page 107. So that's the citation. Now, 14F talks about the way in which you cite legislation. And one of them is the Statutory Instruments Act, which I'll be going to shortly. And it also tells you how to cite Commonwealth legislation or other acts of Parliament. Section 15 is relevant. Because a reference to an act is a reference to the fact of an act having received royal assent. Until royal assent, the act has no force and effect. So those of you that are going to do well in statutory interpretation will also need to find a way of determining the process of royal assent, but more particularly, when royal assent did occur. I think Queensland legislation website, More Than Ausley, is useful in that regard. Again, you need to find legislation from multiple sources. Another good one is Jade Barnett. And then, of course, we have Westlaw and LexisNexis, CCH, which all provide access to legislation. They're paid subscriptions, so I haven't gone into my university library account for these. I'm just going through those sources that are publicly available. But I urge you, and I go into this in great detail in the legal research videos, urge you to go into your university library account, access some of these paid services. They're absolutely excellent. And, you tend to find that students and practitioners prefer one over the other. Some people may say, oh, I like Westlaw. That's my go-to. Others might say CCH. For me, it tends to be LexisNexis, but it's all personal preference. But you do need to consider those paid resources. I will mention and I don't like too many anecdotes, but I will mention that whilst I did do very well at university and got honours at a stage where it was not easy to do so. But leaving that aside, I didn't do so well in my first half of Introduction to Law. I went and saw my lecturer and explained my study technique in response to a question and was told that that's a good start, but it's nowhere near good enough. You need to read cases in full. You need to look at source material like I'm describing to you now. You need to broaden the approach considerably. It meant a lot more work, a lot more material to take in and then condense. But I got the idea and then kicked on from there. So you'll need to do the same thing. Now, I don't want to burden you with too much reading. I get that. And I get that many of you may say, well, I'm not doing this. I'm not going to be a lawyer for a living, but we're doing statutory interpretation. We're doing law. So I still want you to do it properly and to a good level. Now, just as an aside, when you get a lot of material and you're wondering what to do with it, I've got some excellent tips for you in my video about level 3 preparation, and you want to get to level 3. Have a look at that video. So when we talk about Section 15 and the interpretation of acts, bear in mind the particular role that royal assent has in terms of that legislation. Then we have Section 15A. An act commences on the date of assent, that is royal assent, unless the act expresses otherwise. So there's the general rule, which is in 15A, and then there's the specific rule in a piece of legislation. Remember, the specific rule in a piece of legislation, to the extent that it's inconsistent with the general rule in the Acts Interpretation Act, does apply. What's your citation for that proposition? I'm sure you'll all remember. So Section 15A, and within an act, the date of assent of provisions may vary. It may be that, Chapter 7 comes into effect on the 1st of January, some stage in the future, whereas the rest of the Act comes into effect upon assent. So there can be that variation. You need to look for that. And of course, examiners love to see if people are aware of the dates of assent of pieces of legislation. So just because an act appears to be in force at a time, so you're answering a question, remember, of course, that it might be a little trick, and the part that is being examined came into effect after the facts contained in the scenario. I hope that makes sense. Also look at Section 15B, which provides for the time of commencement of acts commences at the beginning of the day. So you don't have to worry about whether the assent was at 1 o'clock in the afternoon or 1 o'clock in the morning. It's always at the beginning of the day, 12:01 a.m. So to that extent, the Act may have some very slight retrospective effect. Let's also finally, in this part of the discussion, we'll have a look at section 20C. But bear in mind, whilst I'm selecting some sections for you to consider, I do want you to read all of this Act and be ready to use it. Creation of offences and changes in penalties. This section applies a lot in criminal law. An Act includes a provision of an Act, because we know that provisions of an Act don't necessarily come into effect when the Act comes into effect. If an Act makes an act or an omission an offence, the act or the omission is only an offence if committed after the Act commences. If an Act increases the maximum or minimum penalty or the penalty for an offence, the increase applies only to an offence committed after the Act commences. I mentioned last week that, particularly in the context of, say, historic sex offence trials, we need to be mindful of what the law said at the time, what the penalties were at the time, because that's the basis upon which the matter will be determined. And what's your authority for that? Section 20C makes it clear that these matters are not retrospective. Now, some things are retrospective. So good interpreters of legislation will have a chart, like a worksheet setting out where there are these snippets of valuable information to consider. All right, just briefly, we'll look at the Acts Interpretation Act Commonwealth, and you'll see an example of that, section 15AC, where an Act has expressed an idea in a particular form of words and a later Act appears to have expressed the same idea in a different form of words for the purpose of using a clearer style. The ideas shall not be taken to be different merely because different form of words are used. Now that's really significant, because what it does is gives a nod to the way in which lawyers have developed, particularly over the last 30 years, towards plain language drafting, sometimes known as plain English drafting. So when I started in law, and I started in practice in a large law firm, and I was involved in reading leases and mortgages in particular, the wording was extremely archaic and was based on the wording used probably at the turn of last century. Very long, involved sentences, repetitive, very difficult to read. About 30 years ago, things started to change, and the emphasis became on using minimal words, direct words. You'll hear this a lot from me, in the active voice, not the passive voice. I need to do some research. All towards plain language drafting. Now, drafting using minimal words is difficult. And generally, it's easier to draft material if you're prepared to allow yourself the luxury of using as many words as you want to. Now, Parliament now wants to use plain English style. And it will do so, but it will have to do so within the context of existing law. So section 15AC gives some idea of the way in which plain language drafting may change the words, but not necessarily the meaning. And I hope that makes sense. All right, just finally, a piece of legislation that is not often considered, but is nevertheless important, is the Legislative Standards Act. And this is a piece of legislation that I go into a lot in advanced statutory interpretation, but it talks about the mechanism by which an explanatory note becomes into existence. The explanatory note, part of the important extrinsic material that we talked about. So do consider the Legislative Standards Act and also the Statutory Instruments Act, both 1992, that provide some further background to the introduction of statutes. If you wish some more detail on that, have a look at the excellent legislation handbook produced by Queensland Parliament, Department of Premier and Cabinet. I've just highlighted example 6.11 dealing with explanatory notes. But you'll note from the index that there's a lot of material that would help you considerably when it comes to statutory interpretation. Time permitting, we'll come back to that, but I do want you to look at that. And also in a Commonwealth context, because it's difficult sometimes to find when and if there was an explanatory memoranda in existence, this website from the Australian Parliament provides some useful information about that. Well, you've been very patient. I've talked probably longer than I had otherwise intended. That's all for this session. We look forward to seeing you in the tutorials. And please, if you have any questions, ask through Q&A or even leave some comments on this video. All the best. See you then.